Hey, it's 8 o'clock. And I understand if the members would take their seats. We're waiting on a couple. I got a couple of emails. Apparently it's bad storming around. And some of the members have sent me emails that they're going to run about 5 to 10 minutes late because of the weather. Representative Howe, how was the drive from Salina? No bad weather? Okay, it must be east of us. So, well, good. Wasn't bad from Kansas City? Yeah. He's trying to emulate his chairman. I know it's a goal of yours. You've got to get your hair a little grayer, though. Okay. Well, committee, when we met last, I did not know we would have another meeting. But, you know, we're in veto session, and we all see the light at the end of the tunnel. So we're just going to take it easy. I'm going to see who's on WebEx first.
We have Debbie Beavers, Jordan Mahalahan, Matt Sterling, and Samantha Potter.
Samantha, are you in the building? Representative Potter, are you in the building or on your way in? Unknown.
Yes, I am in the building.
Okay. We're missing Representative Woodard. Yeah. Representative Henderson. Representative Burris. Yeah, Representative Arnkamp's not with us. You got to roll. I mean, do you know who's here and who's not? Okay, how many do we have here? Tell me how many we're missing. Okay. And Potter's on WebEx. She's not responding, so I don't know if she's in the building or not. Well, committee, we're going to take up a bill today we've had before. It was referred back by the Speaker's office. And so it would be, Representative Henderson's now with us. Good morning, sir. Do you have bad weather coming in? No, not too bad. Yes, Representative Clayton.
Mr. Chair, I've just received a text from Representative Woodard. He is on his way in. So,
Do we know how far out?
10 minutes.
10 minutes. Tell him he must have had a rough night last night.
Mr. Chair,
Yes.
I also received a text from Representative Burris. He's about 10 minutes out.
All right. Well, we got 10 and 10. That's 20 minutes. Anyways, we're going to kill a little time, and I'm going to just let folks tell me, you know, basically maybe the freshmen, how do you think it's gone this year? I mean, you know, have you enjoyed this experience, Representative Howe? Or next year you're going to say, I'm not going to sign up again?
Mr. Chairman, it's been a pleasure to serve with all these members here. I've been driving back and forth each morning from Salina in my district, and so I'm ready to roll here. I have an amendment. When
the appropriate time is, we'll hear from that.
Yeah.
Now, you drive it every day, and you live about 20 miles further than I do, and I admire you. You know, there has been 2 or 3 days that I would drive it when you have to get up at 5:45, 5:30, and get up, and get dressed, and then drive all the way up here. And the closer I would get to Topeka, the more depressed I would get. Of course, it worked in the opposite direction on Fridays when I was heading home. I was feeling much better closer I got to Abilene and home. But I know you've got small children, so this kind of shows me what kind of father you are. It's got to be a good deal to get the kids get to see you every night and get to put them to bed.
Mr. Chairman, will you be making the members that are late do push-ups, or what type of corporal punishment do you employ?
You know, I've thought about that. In my younger days, if I had personnel and drop them for push-ups, I would drop and do push-ups with them, just to build that bond. But I don't build those bonds anymore. You know, from the days of doing 50 push-ups or whatever to a day of maybe 1. But that goes with age. Everybody have a good break? Anybody had something interesting? I know my vice chair sent me some great pictures from Mexico, St. Lucia. I'm sorry, St. Lucia. I'm surprised she came back after seeing the pictures. Didn't want to, and then of course Representative Miller probably went somewhere exotic, as he always. Wichita, fairly exotic destination. For those who don't know, a couple of years ago he went to Cuba, which is something I wanted to do. And one of these days, if the bar is lifted by this president, I'm just going down to look at the old cars and the structures, kind of neat areas. If we're still waiting for people, I'm going to ask Connie to kind of give us tell us what she did on her break. I think she put in windows and new hot water heater. I bet those were exciting times. Representative Wagner, you have anything to share?
No, nothing. Thank you.
Okay. Well, he probably had some good stories. He doesn't want to share his stories. Representative Heiberger, did you do anything exciting? Or were you in court? Okay. All right. Whatever. Okay. Oh, I went to Florida. I took my 2 kids, their spouses, and all my grandkids, and was on the beach in Indian Creek. And 3 grandchildren with 12, 7, and 6. It was exhausting. But good. And I was able to celebrate my 70th birthday. I know I don't look 70, but I celebrate that.
Mr. Chairman?
Yes?
Representative Clayton might want to talk about her new roommate.
Oh, Representative Clayton, what's going on over in your room? It's a party every night.
This does sound very strange, but a squirrel managed to get into my room a couple of nights ago. The terrace door had come open, and so hilarity ensued, and we managed to expel the small creature from the room. There was some effort involved.
I know. I was coming into the building, and I see this one individual that sits in this committee with a shotgun, trying to chase it down the hallway, firing rapidly.
Well, luckily, I don't need guns to solve my problems. I managed to get the squirrel out without using one, so it can be done, committee.
But you put it back into the hallway where it would get into other folks' rooms. You didn't chase
Just
it out the window.
be careful and check under your bed before you go to sleep, Mr. Chair. We never know where that animal might be.
I was forewarned that we had a vicious animal running the hallways. Kind of reminds me of the time that Jimmy Carter got chased by a jackrabbit. For those who remember the 70s. Fortunately, the Secret Service was out there. Oh, yeah, I always look. Representative Penn, you're laughing, so you must have a nice story to tell us.
Mr. Chairman, I'm so sorry. Y'all are hilarious. The most exciting thing that I did was also Wichita, an exotic location, and had breakfast with some of the members, and that was very cordial.
And pretty boring. Representative Smith, did you have any exciting arrests? You didn't arrest any legislators, I hope.
Not me. That was not me. No. I got to take a fantastic 14-and-a-half-hour drive up to Wyoming to look at exotic jails in the mountains. Beautiful. I'll bet you there were over 200 antelope right there beside the road and one in the road that we narrowly missed, but beautiful trip. During the snow, we left during the snow, and so everything had about 1.5 feet of snow on it up there, and it was awesome.
Were you up there to pick up a prisoner?
No, we're just kind of looking at facilities to see what they're doing. We've got an idea to maybe build one.
You always struck me as the kind that would go on vacations and go to different exotic jails to look at. I mean, that's got to be exciting and someone in your profession.
Yeah, it keeps me up at night.
Representative Hoyt?
We had remote third grade going on still, so it was nice to be at home with my son, and I picked out some paint. We're going to paint our house. Well, I'm not going to paint the house. We're going to have somebody paint our house, so that was very exciting, stressful decisions to make. Yeah, no, just pretty relaxing. Went on some walks in the neighborhood.
Good. We want an exciting story. I looked at Dr. Epley. He went to New York. Yeah. If I recall correctly, you went to like a major ball game in the park. Who won the ball game? Your grandson? Okay. That's got to be exciting to go. When I go to Texas, I get to, on occasion, go watch a soccer game or something. Yeah. Okay. Have we used 10 minutes up? Or we have? Okay. I'm going to see if Representative Potter is on. Representative Potter, are you out there? In Neverland?
Just walking into the building.
Is she on? She's still on?
Can you hear me?
Well, we're going to go ahead and go forward and start. We do have a limited amount of time. So, as to a House substitute for Senate Bill, yes. Oh, yeah, that's right. I agreed to do that. I had to do some checking with the rules, and there is no rule against this. Normally, we don't have committee meetings during the veto session, but I will ask for bill introductions, and I'll look at Representative Hoyt.
Thank you, Mr. Chair. I have 21 RS 2227, that's 2227, concerning crimes, punishment, and criminal procedure relating to the criminal discharge of a firearm, working with some folks in Johnson County in response to some close calls on stray bullets exiting properties. And
Matt, are you on?
Yes, Mr. Chairman.
We can see his words. Give me that RS one more time.
Mr. Chairman, can you hear me?
2227.
2227. Matt, if you can hear me, do you have the bill that was introduced, 2227?
Yes, I do. Can you hear me, Mr. Chairman?
May make it very difficult to have a committee meeting. Yeah, Matt, we cannot hear you, and nor can we see you.
Okay.
We can? Okay. We're going to reset the room, Matt. So just hold on. We could. Matt, is there any way you could come up here to the committee room if we don't get this fixed? It's 8:24. We'll come back at 8:34. We'll take 10 minutes. All right. Okay, well, we have the reviser present, so we can go forward, members. So, with that, as to House substitute for Senate Bill 158, what is the pleasure of the committee? Representative Arnberg?
Thank you, Mr. Chair. I move that we pass out House substitute to Senate Bill 158 favorably for passage.
And I have a second from Representative Reese. Discussion. I just want to mention a couple of things. We've had this bill for a couple of different times, and I think we kicked it out. It came back. And I'm mostly doing this for the freshmen. Those other reps who've been here understand that this is a process. This is the first step of a process. If we should at some point in time run this on the floor, there'll be a number of amendments offered. Some will get attached, some will not. Then it will go to the Senate. And when it comes back from the Senate, many of us will not be able to even recognize our original bill because the Senate does have a say. And at that time, if we can't agree to the Senate's version, then we will do a motion to non-concur and then go to conference. And then at conference, if we can arrive at some solution or agreement, we will then run it on the floor of the House again. So this is just the first step of the process. So with that, I've opened it up for discussion. I would recognize Representative Carpenter.
Thank you, Mr. Chairman. I do have an amendment, and it's over here if you'd like to have it passed out.
Jeannie, would you pass it out, please? It appears to be a long amendment. Would you like to explain the amendment and then, or have the reviser first?
I'd be more than happy to go through it, and then if the reviser would like to try to
Enter
mop up
question.
anything else that I miss.
Okay.
All right. So over the break committee, I worked with Representative Garber, and I think we came up with a comprehensive compromise here in this proposal to try to move this bill forward here in the House. So on page 3, we struck lines 17 through 28, which was a part of the Garber Amendment, and we added the original language back into the bill. And the original language from the original marijuana bill. And then we also, later on in the bill, added section 19 back into the bill as well, which is the mechanism for the Medical Marijuana Advisory Committee and their ability to, people's ability to submit petitions to that committee and then add ailments and illnesses to this list. So that is on page 3. On page 5, right now, the Medical Marijuana Advisory Committee does not have a term of service listed on it, so those appointments are basically in perpetuity. We do have, these people are selected by the governor, the president of the Senate, and the Speaker of the House, and we know that there is obviously turnover, natural turnover in those positions, and so felt like it was a good idea to add a 2-year term to those appointments so that they naturally terminate, and then new appointments can be made if the people so chose. On page 6, this is the old section 19 language, basically just adding back in the Medical Marijuana Advisory Committee and their function when it comes to petitions and recommending those items for the secretary, or for the KDH&E secretary. On page 9, we've added the original language of the bill says that a dispensary may request verification by the KDH&E department. I think that that is something that we should go ahead and just make mandatory, have it to where the license are scannable. And KDH&E has agreed to this language and said that that was their plan all along. And so this just puts that language in line with what their intentions are. On page 12, we've added language here to make it a 6-month minimum patient-physician relationship. There are many exemptions to having to wait the 6 months. For instance, if you are a veteran, you can, and you get your care from the VA, you've never seen a physician regarding your conditions or anything like that, you can go to a physician and your 6-month wait is waived. So if that individual has PTSD or what have you, they could get help immediately. On page 14, we modified the advertising sections over the next several pages, and this makes it to where if, so in the original amendment that I had, I believe in Carpenter 1, we prohibited outright advertising on billboards. And so we have since struck that language and modified it. And so we have moved the billboard language, advertising language, to the same standards as television and radio. On page 14, on page 16, we've made it to where the advertising package has to be approved within 21 days by the agency. And if they don't deny it, then the advertisement shall be deemed approved. And then also on page 17, we have made it to where we took California law here on this one, and it was 15 miles from the state line. We lowered that to 10 miles from the state line on a prohibition of advertising on billboards specifically. If say you have I-35 that goes from Kansas into Oklahoma, it starts at the state line and goes 10 miles into Kansas, and then after that you can have the billboards. However, if we have a highway that is 6 miles from the state line and it's running parallel to the border, then you can have your advertising there because it doesn't cross the state line. It only applies to highways, interstates, and whatnot that are state-owned and that cross the state line. On page 21, we have we made it to where cultivators have to cultivators that get licenses and demonstrate the ability to grow medical marijuana, they have to do it in a secure indoor facility, which so that they can maintain control or adequate control against diversion, theft, or loss of medical marijuana. And then on page 26, we have it to where we did modify the fee structure slightly to where a minimum of 1,000 plants need to be purchased, so that we can make sure that the people who are growing the medical marijuana have the ability to grow enough for production purposes. And then so basically you can purchase 1,000 minimum, but then you can grow 500 or what have you if you feel that is how much you have the capacity to grow. And then it's after 1,000 plants, it's $20 per plant after that. On page 28, this is in regard to an issue last week where I was down in Oklahoma, and they have problems with foreign interest and I would just say crime syndicates currently. So I think that we wanted to make sure that when people purchase the licenses, that they disclose if there's any foreign financial interests within those. And so we took this language from a current bill that's in Oklahoma, just to make sure that the people who are purchasing the licenses are above board. And it is a penalty of perjury if they lie on that attestation. On page 31, this is, I believe, cleanup language at the top, but down towards the bottom, it is the county opt-out option for dispensaries within the local county. However, in this language at the bottom of page 31, we have it to where if a dispensary is set up inside of a county and a county board of commissioners decides that they no longer wish to have medical marijuana dispensaries within the county, and then they adopt a resolution to make it to where no more dispensaries can be open. Those dispensaries that are in current operation will continue to be allowed to be in operation, and basically they are grandfathered in from the county opting out. So we don't want counties, after businesses have been set up, to be able to close those businesses. And basically, you could have one county commission that supports it, one county commission that doesn't, and it could go back and forth, back and forth. So we decided that that was something we needed to do to provide a little bit of stability for those businesses within that county. On 32, page 32, we felt that this language needed to be changed because on line 33 it said the secretary's decision shall be final, and then under the current language in the bill, it talked about the director, and we felt that that needed to be the secretary, because otherwise, if we don't change that section, then the secretary's decision will be final, and it appeared that we wouldn't be able to resubmit a petition after 12 months, and that is for the method of using medical marijuana, form or method of using medical marijuana, and that's petitioning for those items. On page 35, that's just back to the another section that talks about an indoor grow operation. On page 38, we struck lines that removed the petition process for a business or for a licensee to be able to petition to set up shop within 1,000 feet of a school, religious organization, public library, or public park. And so we just outright removed that petition process because I don't think that that's something that we would like to allow. However, if one of those entities, school, religious organization, or what have you, decided to set up within 1,000 feet of a licensee, that would be their choice. And so they would have the ability to make that choice. On page 42, we added back in the language that was in the original medical marijuana bill of minors and basically negligence of storing medical marijuana products. On page 43, changing the Division of Alcoholic Beverage Control name to Division of Alcohol and Cannabis Control. And then also in new section 56, adding a new provision in here to protect folks' Second Amendment rights, in that if somebody has a medical marijuana ID card, that they will be able to keep their firearms, and that the law enforcement within the state of Kansas cannot go in and enforce federal law and remove people's firearms because they are they have a product that has been given to them legally or is legally recognized by the state of Kansas. On page 44, this section okay, so this section is also, I believe, in regards, and the revisor can correct me if I'm wrong, this section is in regards to making it so that the Attorney General for the state of Kansas, their office, they do concealed carry licenses. This is removing the exemption for the licensing under the Attorney General's office. So if somebody is a concealed carry holder, they would then have the ability to have their concealed carry license and also be able to obtain medical marijuana products as well. And then for the last several pages, and I would actually say I will let the revisor, if I may, Mr. Chair, discuss attachment 1 and attachment 2.
Go ahead, Matt.
Thank you, Mr. Chairman. We picked a fine morning for technical issues, didn't we? So the only things I would add to Representative Carpenter, excellent job running through and describing it. On page, starting on page 42, the amendment strikes new section 54. That would add a new section pertaining to discrimination against the rental and housing issues for an individual based on their use of medical marijuana. And then to add a little clarity on the new section 56, it would prohibit a law enforcement officer from enforcing any violation of a specific section of the Federal Gun Control Act if the substance involved was medical marijuana. And then, as he indicated on page 44, so that those amendments to new section 59 would pertain to any licensing, certification, or registration body. They would not be able to require an individual to disclose the fact that they were a registered patient. And it strikes, so there's a list of agencies that are exempt from those provisions. It removes the Office of Attorney General from that exception and adds in the Board of Healing Arts and the Board of Pharmacy. So then getting on to the remainder, there's also those two other sections in the Kansas Acts Against Discrimination that are removed from the bill. And then the attachments, I'll pull those up. So before you go to the attachments, if you look on page 86 of the bill, there's a new section added, section 88, and this pertains to the attachments that I'll discuss in a moment. Essentially, it's setting up a mechanism that if marijuana is rescheduled by Congress under the Controlled Substances Act, the Secretary of KDHE would certify to the Secretary of State that rescheduling had occurred. Upon receipt of that certification, the Secretary of State would publish notice in the Register, and that publication in Register would then trigger the amendments that are listed in these sections that I'm going to discuss. So let me pull those up. And basically, if you go through section or attachment 1, it's a number of sections in the bill that discuss recommendations for medical marijuana. All of those instances would be changed to prescribing medical marijuana. So upon that change by Congress to reschedule marijuana out of Schedule 1, it would then trigger a change in Kansas law to change all of the parts in the bill requiring a recommendation for medical marijuana to then require a prescription for medical marijuana. That's going through, basically I think there's 8 sections in the bill that have to go through, and that's the change in every single one. Basically just changing all of it from recommendation to prescription. And I guess I'll pause to see if there's questions about that since it's a little different.
All right, so somebody's thinking ahead. If the United States Congress moves it from a Schedule 1 to a Schedule 3, where it would be able to, or 2, it would have some medical purpose. Then if the federal government does that, we would not have to come in with this amendment to change anything. That would be the trigger that would just automatically say, well, you no longer recommend, it would be a prescription from a medical doctor. basically that's the changes. That's a good, I'm glad somebody was thinking ahead, because that could happen this year or next year with the United States Congress. Okay. Any questions based on that section there?
I have a question. Thank you, Mr. Chair. Matt, this is for you. Back in section 1, there's a list of conditions that are given. My question is this: we put a process in to add conditions. What is the process? And I know this is ridiculous to think we'd take any condition off given the omnipotent and unlimited healing properties of this substance, but if we were to remove a substance, if the Board of Healing Arts would find that a condition was, it would be contraindicated to use marijuana for that condition, yet it's listed in the statute, how would we remove that? Would the legislature then have to remove that, or could the board do that themselves?
Sorry, you said section 1. Were you referring, which part of the amendment were you referring?
Page 3, lines 1 through 17. How would we remove any of those conditions should we find out that it's actually dangerous?
So that would be through a process of the legislature amending the statute.
Thank you.
Further questions? You want to continue, or you want Matt to continue? I'm sorry. Yes, Representative Heiberger, sorry.
Matt, on the second section of section B of section 88, it lists a series of sections that are repealed in the event that the notice is published. Could you just summarize what those things that are going to be repealed are?
Thank you, Representative Heiberger. So all those sections are the sections that are amended in attachment 1. So, you know, going through the process, we amend the sections and then we repeal the old sections. So sections, the original sections 2, 3, 4, 17, 18, 35, 44, and 215706 as amended by section 72. And then 65, 4107, and 65, 40, or I'm sorry, those are all enacted in the bill. If the trigger mechanism of Congress rescheduling marijuana occurs, then all those originally enacted sections would be repealed, and then the new ones that are in the attachments would be enacted with that change from recommendation to prescription.
Okay, so everything that's being repealed, sections 2, 3, 4, is would be replaced by things that are in these attachments.
Correct. It'd be replaced with the only change being in that change from recommendation to prescription.
Okay, got it. Thank you.
Okay.
Thank you, Mr. Chairman. And earlier, Matt, you had talked about the Kansas Act Against Discrimination pulled from the bill. Can you elaborate on that?
So there are 3 sections in the bill. There's new section 54, and then there's, what is it, section 70 and 71 that pertain to discrimination based off of an individual's use of medical marijuana, and the amendment removes those from the bill. So it's not eliminating them from law, it's just removing the changes that made to them in the bill. So they're being stricken from the bill.
My understanding is you can't discriminate against someone if they have medical marijuana.
Oh, that's like in housing or other situations of that nature.
That was the change that was made originally, and those provisions are being removed from the bill. They're being stricken.
Okay, thank you.
Representative Howe had a question.
Yes, I had a question on page 9 regarding the identification number that's electronically scannable. Will that have a photo identification on there, and also is it tied to any medical record?
Well, I'd say neither of those are spelled out in this. That could be something that KDHE establishes through their rule and reg process. I don't know if they anticipate doing that, but that's not spelled out and required in the statutory provision.
Further, Representative, you do it. Go ahead. Go right ahead. I'm sorry.
So that was attachment 1. There's 2 other attachments to the amendment. Attachment 2 is the change to 19101A, the county home rule powers. that there's just a new paragraph saying that counties can't exempt from or affect changes in the Medical Marijuana Regulation Act, except as they do in that section 35, where they can adopt a resolution to prohibit the establishment of a dispensary. And then the last change is attachment 3. So again, this is part of that trigger. So if Congress reschedules marijuana under the Federal Controlled Substances Act out of Schedule 1, this would also effectuate a change in the Kansas Controlled Substances Act to move marijuana under Kansas law from Schedule 1 to Schedule 2. It would not pertain to the synthetic forms of marijuana, just the natural forms of marijuana, but you can go through attachment 3. It's a long drug table, basically just moving marijuana from Schedule 1 to Schedule 2 under Kansas law, again, triggered if Congress reschedules marijuana out of Schedule 1.
Questions as to the last two attachments? Yes, Representative Wagner.
This actually slightly goes back to attachment 1. You're saying that if the federal government would legalize marijuana, that then the medical marijuana would become an actual prescription drug, as it would be? And is there the difference between recommendation and prescribed, is there not some, in the medical society, impact to that change?
So the change wouldn't be, so if Congress just moves marijuana, right now it's Schedule 1 controlled substance. If the trigger is if it moves it to anything else, so it could be Schedule 2, which is like OxyContin, then that would trigger these changes in Kansas law. In terms of prescription for a Schedule 2 drug, there's a couple requirements, and I'm sure Dr. Epley knows a little more than I do, but there's a couple requirements. They require a written prescription. You can't get refills. I can't remember if there's other requirements, but the Kansas law would require a prescription from a physician as opposed to just this recommendation.
And Dr. Epley, if you care to be in.
I'll attempt to, Mr. Chairman. So thank you, and thank you for your good attempt there. I do believe that, I guess what I'm concerned about, if it goes from Schedule 1 to Schedule 3, and this is crystal ball stuff, and I haven't read this attachment thoroughly, so I'm curious, is Attachment 1 only specifying that it would move to Schedule 2 in Kansas? Because I think we would default to whatever the federal government does on the DEA listing on that. Isn't that correct?
So that may be what the legislature chooses. So as far as drafting this in a manner that doesn't delegate any legislative authority, that'd be a distinction to draw. So the way this is constructed, it's saying if this act of Congress occurs, this X is what the legislature wants to happen, which is distinctive from we want to do whatever Congress does. So that would be kind of delegating authority to Congress to say just change it to whatever you guys change it. Mm-hmm. So you're right, it's difficult to anticipate what Congress may reschedule marijuana as if it's rescheduled. And so this is just the next, the Kansas Act would be moved to Schedule 2. If Congress rescheduled to Schedule 3, the legislature would have to come back in and then move it to Schedule 3.
Not to get down in the weeds, no pun intended, but I think that it'll go to Schedule 2 if and when that happens. And then my other question, if I may, Mr. Chairman. So I appreciate the intent, the good intentions of Attachment 1. I guess I would look to the maker of the amendment and ask, what would the impact of this be on those dispensaries that are set up? Are they going to be able to flip a switch and comply with this quickly, or are we going to allow a period of time where there's recommendations coexisting with prescriptions, or are those dispensaries going to have to meet all requirements to become dispensing pharmacies when that happens? And I know that's been discussed, and there's got to be an answer out there. But I certainly don't have it, and I'm looking to the maker to address that. Thank you.
Thank you, Mr. Chairman. I would say that, in my mind, with how this would come together and how I foresee this happening is that if Congress does deschedule and we do switch it to prescribe, my understanding is that it really wouldn't be on the dispensaries that would have a problem with this. It would be a re-education of the physicians themselves, because they would be the ones that would have to change it from a recommendation to a prescription process, and then the dispensaries would just comply with the downstream effect of that prescription now.
And I understand that. And with the former amendment that I placed 4 weeks ago, with consulting pharmacists involved, is that going to allow, I mean, I'm looking to Matt to help me, educate me on whether that will allow dispensaries then to be in compliance with that flipping of the switch so that they can indeed honor prescriptions then of a Schedule II drug from a physician. And that is, I've read that part of the attachment. That's well addressed in there as far as how physicians can transition from being a recommender to a prescriber. I think that's addressed in the attachment adequately. But I'm curious about how it's going to impact the dispensaries. And do you think that will allow them to be able to, if you will, morph into a prescribing entity as opposed to a recommending entity as a dispensary? Thank you, Mr. Chairman.
I mean, I guess the answer I could provide is, so the changes to the dispensaries themselves are limited to the fact that they're now going to be required to only honor prescriptions that have been given for registered patients as opposed to recommendations. The pharmacist consultant piece is unchanged, other than that pharmacist consultant now has to verify the prescription that is accompanying the patient as opposed to just the recommendation. I'm not sure I'd be able to give more or have more than that.
Mr. Chairman, if I may, I just press one more thing. I don't know if the dispensaries are going to be in compliance with the other rules and regulations as it relates to being able to dispense and prescribe state law as it applies to pharmacies. I mean, because once it goes to Schedule II, it will be prescribed at again, I may be caught up in my physician brain of a pharmacy. And if it's a dispensary, are there other rules and regulations those dispensaries are going to have to meet to allow prescriptions to be given out, whatever wording you want to use? And I don't mean to complicate this. I just want to make sure we've thought this through.
Sure. I don't think I have an answer for that other than to say that a dispensary won't become regulated like a pharmacy under state law. However, any requirements specific requirements that accompany a prescription would be applicable. And I can't say that I've thought through that piece extensively. So I don't have a full answer for you. I'd have to check back on what the requirements that accompany a prescription and how they might change requirements for a dispensary in complying with those.
So, Mr. Chairman, just last point, and that is at least having a pharmacist consultant on board with the dispensaries is essential if and when this occurs, such that there would be pharmaceutical oversight on this to meet state law for that to occur for prescribing this medication.
And that piece remains in place. The pharmacist consultant is there with a dispensary when it's a recommendation, stays in place if it switches to a prescription.
Thank you.
Thank you.
Reverend Heiberger? No further questions. Further questions? Thank you. I was going to hit Representative Garber. I'm sorry. Reverend Wagner.
Yes, thank you, Mr. Chairman. Appreciate it. Matt, what is the import of this second attachment on county authority? Is that necessary given what we have on page 33 where this amendment already limits what counties can do?
Well, I'm not sure I would say it's absolutely necessary in terms of trying to be careful in making sure that the provisions are uniform, and so you don't give counties an ability to charter ordinance out of it. That was the reason for amending 19101A. Generally, the practice when we're saying a county can't accept, because we're saying counties can't accept themselves out from things other than adopting this resolution to restrict dispensaries. And so it's basically just trying to be consistent with the way we've gone through in the county charter statute, or charter ordinance statute to say that, you know, this is your home rule authority, it's restricted to this. You can opt out of dispensaries, but that's it.
Hal, did you have a question?
Mr. Chairman, I don't know if it's that important, but I noticed that it would change the name of the alcohol, beverage, and cannabis control. Is that, why don't we use that language, cannabis, instead of marijuana? Couldn't we say enacting the Kansas Cannabis Regulation Act? I don't know what the committee thinks, if there's a difference, but just to be consistent.
I'm going to go back to the maker of the amendment.
I don't really care if we call it cannabis or marijuana. To be honest, if we want to change it to the alcohol and marijuana control division, then cool. If not,
I just didn't know why we're using two different words.
I guess to a certain extent, you know, I just got some feedback from other representatives, and they felt that ACC was a good name, and alcohol and cannabis control sounded better than alcohol and marijuana control. So I really don't care about that section. If we want to change it, then let's do it. But I talked to the ABC director, and basically she said she didn't really care what we named it.
Thank you. Representative Clayton?
Thank you, Mr. Chair. To speak to the cannabis versus marijuana terminology, cannabis is the scientific name of the plant. Marijuana is just sort of, it was actually started being used as a sort of pejorative to associate it with, you know, with South America and that sort of thing by folks who did not support it in order to just basically make it sound worse. But cannabis sativa is the scientific name of the plant. So I think that's in fitting with science, and whatever alliterative name for the control division, I would support the term cannabis just so that we can be above on that. Thank you, Mr. Chair.
Thank you. Representative Smith?
Well, one of the reasons why we can't switch it to cannabis is because that agency won't be in charge of hemp, and hemp is also cannabis. So it separates the two substances. You have hemp and you have marijuana. If you say cannabis, it basically incorporates both.
But cannabis is just the name of the genus. Cannabis sativa is the name of the actual species. So hemp is a different scientific name. So, you know, sorry, didn't mean to like mansplain, you know, plant taxonomy to you, but that's the reason behind that logic.
And just for clarification, the criminal statute says marijuana. So I have no problems with it the way it is. But Representative Garber, do you have comments on the amendment?
Well, if this...
I understand you work with...
If this is all we're going to argue about, I'm feeling pretty good right now.
Okay.
Name of a...
Well, I want to thank both you and Representative Carpenter. You've worked pretty hard on this for the last couple of weeks or during our break. Representative Penn, you have a question.
Yes, Mr. Chairman. I'm sorry. Are we questioning the reviser right now or the carrier of the bill?
You can.
Oh, okay, good. I have a few questions, please. And I guess this is for the carrier of the bill. When we're talking about on page 21, the amendment, and I'll go on the record saying that I want it to be marijuana and not cannabis, regardless of genus, phylum, or species. The applicant is applying for a cultivator license, demonstrates the ability to grow medical marijuana in a secure indoor facility and maintain adequate control against the diversion, theft, and loss of all medical marijuana, and to be grown by the applicant. And you see that one show again. What does that exactly look like? Is it a two-factor authentication? Can we specify there?
The reviser can correct me if I'm wrong, but I believe that the provisions for that would be determined by rules and regulations. I see the reviser kind of nodding his head yes. So it'd be up to rules and regulations to determine what does secure mean, and how would the director of alcoholic beverage control facilitate that as a secure facility.
Thank Yeah, thank you, sir. I appreciate that. I just think that one of the things that we can do is, as we see with so many different things here in the legislature, is actually give the legislative intent so that down the road we don't have a lot of hemming and hawing about exactly who had what type of security in place and does it meet muster.
Thank you.
So,
Thank you. I have no other questions on my list. Now,
oh, sir, I had a few more.
I'm sorry. You waved.
Yeah.
Please, but make it brief. I'm looking at the clock as I always do, and we have one period here to get either this is going to die, and some of you want it to die, and I appreciate that. But we're going to have a vote, and whether it comes out or doesn't come out, it doesn't make a hill of beans to me. But I also know that there's a lot of questions, and as I explained up front, this is not the final product. You'll have probably 3 or 4 more votes on this issue. But with that, Representative Penn.
Thank you, Mr. Chairman. For the carrier of the bill or the revisor, talking on page 28, the balloon that you have there says that you're seeking licensure and foreign financial interest. Did you consider out-of-state interest? I know that originally when we were concerning this, we were talking about medicinal marijuana. To me, this particular thing goes with blowing out the industry. So there will be some individuals who will be concerned about whether or not there are monies coming in from out of state and creating a market here, and is that protected for Kansas growers?
With the way the bill is currently written, we have a 75% residency requirement in order to obtain licensure, and so that person has to have 75% interest within their establishment, or within that licensee has to have 75% of that business. And so that is a part of the current bill that we have in place. And so that is how we make sure that the majority of the companies are owned by the licensee for in-state and versus out-of-state residencies. And if the revisor would like to clarify on anything, more than happy to have them.
Good to go?
I guess the only thing I would add, and I'm realizing reading this with your question, whether that you can clarify if that's your intent or not, is drafted as any foreign financial interest. So that could, could be foreign to this jurisdiction as well. So it may not necessarily just be out of country. It could be out of state. If you want to clarify that, we can. But right now, it just says foreign, which could be interpreted to mean out of state.
I think that that's actually acceptable, because that would also help us prove that 75% of the interest is within the state of Kansas.
Thank you. Thank you, Mr. Chair.
Thank you. Hoyt.
Thank you, Mr. Chair. For the purpose of time, I'll just mention that I do not, I am opposed to the provision on page 26 for a minimum of 1,000 flowering plants to be assessed. I would prefer to divide that out and vote separately on that provision, but for the sake of time and not wanting to get in the way of getting this out, I can live with it for now. Thank you.
You're welcome. I think the amendment, I have no other questions. Is there a second to the amendment? Representative Garber seconds the amendment. Further discussion on the amendment? Seeing none? Looking behind me. Okay. Representative, you may close on your amendment.
Thank you, Mr. Chairman. Again, I asked for the committee's support for this amendment. It was something that Representative Garber and I worked on extensively over the break. I think everybody knows that when we originally debated the bill, him and I were miles apart, but I think that we've come a lot closer, and we have a good compromise amendment here to make the bill superior and I think ready for the House floor. And so, Mr. Chair, I close on my amendment. Thank you.
Thank you. Representative has closed on his amendment to House substitute for Senate Bill 158. All in favor of the amendment say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. The bill has been amended. Other amendments. Representative Howe.
Thank you, Mr. Chairman. I'd turn to the revisor if you would like to run down the amendment real quick.
Thank you. Matt? I will advise the committee, I was supposed to finish at 9:30. I have gotten permission from the majority leader to go an extra 15 minutes. So it'll be 9:45. Yes. Yes. Go ahead, Matt.
All right, thank you, Mr. Chairman. So the amendment, Representative Howe, would make several changes to retail dispensaries, requiring a dispensary to be a person that's operated by a licensed pharmacy and who's a pharmacist licensed in the state and registered with the Board of Pharmacy. The second page of the amendment would require, makes the same change to the dispensaries, requiring that any pharmacist that was licensed in the state that sought to distribute medical marijuana would be required to register with the Board of Pharmacy pursuant to rules and regs adopted by the board, and then would add a new section 39 on the last page of the amendment, requiring the Board of Pharmacy to adopt rules and regs establishing requirements for a pharmacy to register as a dispensary and report transactions to the prescription monitoring database. So it's similar but different, basically modifying the requirements for dispensaries that they be operated by pharmacists registered with the board.
Thank you. Representative, you'd like to comment on your amendment?
Thank you, Mr. Chairman. Given the fact that we are legislating a medicine, for medical purposes, I do think it would be wise to treat it as such. And, we already have established infrastructure as it relates to pharmacies in the state of Kansas. It would utilize that current infrastructure. It would also utilize the relationship between a doctor and a patient, as well as a pharmacist. And so I think it would be the easiest transition to approve medical marijuana for the state of Kansas and for the people that live here to ensure the safety and integrity of the medical field. I would stand for any questions.
Thank you. I just have one. The reason Dr. Epley put on the amendment about a consultant, have you consulted with the Board of Pharmacy? Are they allowed to have marijuana? Because they're also monitored by DEA. I guess my question is the Board of Pharmacy in support of this?
Mr. Chairman, I did receive word from the Kansas Board of Pharmacy. They specifically said the board stands ready and willing to take on the responsibility if it is the will of the Kansas Legislature.
Okay. All right. I just wanted to make sure. Is there a second to the amendment? Yes. Representative Burris, your second. Thank you. Discussion on the amendment? Yes, Representative Epley.
Thank you, Mr. Chairman, and respecting the time element, I just want to say we're really continuing to deal with the legal aspects of being on the schedule or not, and that's why I crafted my amendment, which is in the bill currently in the manner in which it is, because I think it's not a boat too far, and I think that this would be, and I just believe that if we enact this amendment, that this could be looked on, this could be litigated, and pharmacies there would be no one wanting to recommend at this time marijuana through a pharmacy because it would be illegal by DEA standards. Now, again, I didn't go to law school, but knowing the schedule of the DEA such as it is, I think that is what we're setting ourselves up here for. And perhaps the maker of the amendment can educate me differently, but that's my concern for this amendment. Mr. Chairman, thank you.
Thank you. Further discussion on the amendment? Seeing none, Representative, you may close on your amendment.
Thank you, Mr. Chairman. I had this amendment before a break and whatnot, just given the time constraints, wasn't given the opportunity to introduce it. So I do appreciate your indulgence and the indulgence of the committee to bring this common sense amendment before the committee today. You know, I find it very interesting that, you know, there's a lot of conflicts with federal law, but I don't want that to get in the way of a common sense solution that could protect the Kansas consumer as well as the medical community at large. I am not against necessarily medical marijuana. I just think it should be very narrow in its purpose and also tailored based on data and sound science. So with that, I'll close on my amendment.
Thank you. You have heard the representative, who's had a motion and a second to amend with the Howell Amendment. All in favor, say aye. Those opposed, no. Opinion of the chair, the noes have it. The noes do have it. The chair has an amendment. You want your registered, Rep. Heiberger, your vote registered no?
Yes, please, and also for the previous vote as a no.
Thank you. Chair has an amendment brought to us by the reviser. Matt, would you explain the amendment? The technical amendment. Connie and Jeannie will pass it out. Go ahead.
Thank you, Mr. Chairman. Well, this is probably going to be the longest technical amendment any of you have seen. But it's my effort to go through and clean up the provisions of the bill. Based off of the changes that were made by the committee when you adopted the substitute bill, there were a number of superfluous and kind of extra sections that I've combined that required a lot of redesignating of sections throughout the bill. There's some changes that I made in terms of clarifying intent with the section pertaining to the restrictions on, and requirements on licensees in terms of not just being corporations, but if you'll see the language on page 18, making sure it applies to limited liability companies, limited partnerships, limited liability partnerships. Continuing on, there's some, it's additional kind of clarifications of the language that was adopted in the bill. And primarily there's lots of markup and changes because I'm striking extra sections and moving the contents to consolidate them into individual sections so that all the sections pertaining to licensing are in one section. All the provisions pertaining to fee structures are in one section, as opposed to being scattered in multiple sections. There were extra fee funds that were in the bill that now, once the committee made the decision to consolidate responsibility under the director of ABC, there's no need for multiple fee funds. You can just do it through one. So that's kind of, there's a lot of changes, but that's going through and basically cleaning all of that up and consolidating them. So no policy changes, just lots of moving parts.
Thank you. I want to thank Matt for getting this. I mean, if without a reviser, we would get into a lot of trouble. I have offered the amendment. Is there a second? I have a second from Representative Hauser. Further discussion on the technical amendment? Yes, Representative Arnberg.
Thank you, Mr. Chair. Matt, a quick question. Since we adopted the large amendment earlier, like on page 41 where it says recommended by the Director of Alcoholic Beverage Control, do we need to change that? And can we give permission in our amendment or in your amendment to do that?
So two parts. One, I would appreciate latitude from the committee, just generally speaking, consolidating all of this. But two, no. So the amendment from the Carpenter Amendment created a new section of law that basically just says every time in statute you see ABC, we actually mean ACC.
Okay.
Now, if this all becomes law, I'll probably be drafting a cleanup bill, a trailer bill next year to actually go into each section and change that. But, you know, I don't think you want like a 1,000-page bill right now, so.
Not 1,000. Do I have a second? I have a second. Further discussion on the technical amendment? Yes, Representative Garber.
Thank you, Mr. Chairman. For the reviser, I'm looking on page 82 about the registered nurses. Is that going to be, I don't see that in here.
So on page 82, pertaining to that, there was, the way I drafted that originally when the committee adopted the substitute bill, there was an incorrect reference, and so I'm removing that incorrect reference, so it will just read, medical marijuana exemption, the board shall not deny, revoke, limit, or suspend the license of any licensee, publicly or privately censure any license, or publicly or privately censure any licensee. So it's applicable to all licensees. It removes that erroneous reference to the Medical Marijuana Regulation Act.
Thank you.
Thank you, Mr. Chair.
Further discussion? All in favor of the technical amendment, say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. I do have another amendment. Matt, the one from the secretary, or the treasurer, state treasurer. Do you have that one? This is requested by the state treasurer, and I think it's only a change of a couple of words, right? I'm going to pass that out. This is at the treasurer's request. It's a 2 or 3 word change. Yeah, go ahead, if you'll go through it real quick.
Yeah, so on page 37, new section 46, it talks about the director of ABC, in cooperation with the treasurer, establishing a closed-loop payment processing system. This would strike the words closed loop, allowing it to be open loop as well. So it just allows the state treasurer additional latitude in establishing that payment processing system.
Thank you. It's been explained. Questions? Do I have a second? Representative Reese will second it. Further discussion? Seeing none, all in favor of the amendment, say aye. All opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. The bill is amended again. The ABC. We have Chair has another amendment at the request of ABC, who will be the regulators to this bill, and they find that they need a little latitude. So while we're doing that, Matt, if you would explain.
Thank you, Mr. Chairman. Several changes will be made here. One, if you just to the definitions section, there's a number of definitions added. Rather than requiring those to be established through rules and regulations, this would be going through and establishing those definitions of cannabinoid, cultivate, medical marijuana product, medical marijuana waste, person, plant material, tetrahydrocannabinol, tetrahydrocannabinolic acid, and tetrahydrocannabinol content. So it's establishing a number of definitions that are used throughout the bill and actually defining them as opposed to requiring them to be defined through rules and regs. Additional changes, there is a discrepancy in terms of the residency requirement in terms of the duration for individuals. Some were 2 years, some were 4 years, some were 5 years. This would just make all those durational requirements uniform at 4 years. Additional change, the establishment of, so right now the ABC director has to contract with an operational private lab for basically quality assurance, conducting quality assurance testing. Right now it has to be done by January 1 of 2022. The amendment would kick that out a year to 2023, and then would also do the same on page 34 of the bill for the rules and regs adopted by the director of ABC. Right now, that's July 1 of 2022. That would also extend that out to 2023. And then there are changes made to the fee structure. One, clarifying that the license applications are non-refundable. And then two, it would change the actual cost of the fee structure to being $15,000 for a licensee that cultivates medical marijuana in an area that doesn't exceed 3,000 square feet, and then $195,000 for one that does exceed 3,000 feet. So it's reverting back to some of that original language pertaining to square footage and the fee structure. And those are the changes.
Thank you. Questions of Matt? Yes, Representative Potter.
Thank you, Mr. Chair. I'm curious why we went with 4 years instead of 2 years on all those changes, because 2 seems like a better option for me.
I don't know if I could say why, just that it was inconsistent use throughout that provision. There was some that were 2, some were 4, some were 5. The director expressed a concern that that inconsistency could have legal issues. Basically, one licensee be getting treated differently than another. So I just made that uniform.
Thank you, Mr.
Certainly,
Chair.
committee's prerogative to change that duration to whatever it wants.
Thank you, Representative Carpenter.
Thank you, Mr. Chairman. I don't think I see very many issues with this until we get to page 26, and then the fee structure has been modified by ABC, which we just discussed in the amendment that I brought forward earlier. So I was curious to see if that is something that we might be able to carve out in our consideration of this amendment and just consider everything else within it. Thank you, Mr. Chair.
Thank you. Further questions? How?
Mr. Chairman, I don't know if this question would be for the reviser or somebody else, but if the plant that is cultivated goes beyond the THC limit, what is the process for the cultivator? What does he do with that? I know this has come up regarding the hemp legislation that we considered in the House earlier with the state fire marshal. I didn't know if there was something similar to that in here.
I'm sorry? My vice chair was talking in my ear.
The question is, in the overall bill, as it is currently presented before the committee, if the cultivator has plants that are above a THC level of a certain amount, is there a disposal mechanism that ABC, is that what ABC is looking for, a way to dispose?
I will look to Matt for that.
So the percentage cap on the THC content that's in section 36 of the current bill applies to the final dispense form, not on the cultivated medical marijuana. As far as the, so I guess in terms of those definitions, that, you know, in terms of the product and medical marijuana waste, I think the idea was just to establish definitions that rather than going through the rule and reg process of using those, it was to just provide those definitions in statute.
Thank you. And to get back to Representative Carpenter's question. Representative Carpenter, I'm sorry, you'd asked a question. I wanted to go through my head and make sure I knew the rules. You could make a motion to strike that portion of the amendment. If you should choose it, if you would prevail, it would be struck from the amendment, but the other parts of the amendment would not be struck.
And yes, Mr. Chair, I would like to offer a substitute motion to strike the provisions concerning the fee structure on page 26 regarding A and B.
Which is a large box there.
Sir.
Thank you. I have a motion and I have a second. I represent Arnberger to strike page 26, the large box, A and B, one being the $15,000 for a license and B being $195,000 for a license. Further discussion on that substitute motion? I'm sorry. Representative Hoyt?
Thank you, Mr. Chair. I'm not going to be supportive of this motion. As I mentioned on the previous amendment, that was the component of the I had issue with, and I think that the change reflected in this amendment addresses that concern. Thank you.
Thank you very much. Further discussion on the substitute motion to strike portions A and B on page 26. Seeing no further, all in favor say aye. Yep. All opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. That portion of the amendment is struck. Back on the amendment. Representative Hoyt would like to vote her yes, her no, and Representative Heiberger's no. Thank you. Back on the amendment. Further discussion?
Yes, Mr. Chairman, I had a question.
Oh, go right ahead.
For the reviser, We discussed earlier that there was supposed to be a strength lab for KDHE to stand up to ascertain the strength of the products that will be distributed. Does this amendment or your understanding of the bill as amended, does anything address the standing up of that lab, and what is the cost associated?
Matt?
So under, let me pull up the section. So there's section 23 that requires that the director to contract with that private lab, which is basically for the purpose of conducting compliance and quality assurance testing of other laboratories. So it's the director has to contract with a specific lab that'll be kind of like the state lab in terms of identifying testing practices and ensuring uniformity. The amendment delays that contracting for a year. So instead of doing that by January 1 of 22, it's January 1 of 23, because this is also extending out when ABC would be adopting regs, and that'd be July 1 of 23 instead of 22. So it's pushing everything out a year.
Thank you.
Yeah, to clarify, sorry, the bill goes into effect on statute book, but there's a number of requirements for adoption of regs and things, and that's being pushed out a year.
Thank you. Further discussion, all in favor? Who? I can't, you're blocked by my view. Sorry, Representative Garber. Go ahead.
Yes, on page 26, line 26, another date there, January 1, 2022, should that be changed to 2023 also?
After January 1,
So-
2022?
I mean, it can be. It's this date, just basically after January 1 of next year, accreditation by that entity would be required for licensure and renewal of laboratories. So under the current structure, that was going to be based, I don't think any labs were getting licensed before then anyway, other than this provision. So I guess if the committee wants to make sure that the quality control lab doesn't have to meet that requirement, that would be kicked out. Otherwise, there's no change for other licensees.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Further discussion? Seeing none, Chair will move its amendment. It was requested by ABC. I have a second on that, with Representative Arnberger. Thank you. All in favor of the ABC's amendment to House substitute for Senate Bill 158, say aye. Those opposed, no. Opinion of the chair, the ayes have it. We're back on the bill. If we can do it quickly. Chair has another amendment. This is an amendment by Health and Environment. That's all it does is kick it out 1 year so that they can get the rules and the regs done. Matt, it's a one-pager, I think. Matt, while you explain it, while he gets...
Thank you, Mr. Chairman. So the amendment would make two changes to page 10 and 11 of the bill, new sections 14 and 15. So under the current bill, Secretary of KDHE has to adopt rules and regs to administer the Medical Marijuana Regulation Act by July 1 of 2022. This would extend that out to 2023. And in section 15, the Department of Health and Environment has to make a website available to the public to access information regarding patient and caregiver registration under the Act. Currently has to do that by July 1, 2022. Again, this would extend that out to 2023.
Thank you. Do I have a second on the amendment? Representative Penn, second to the amendment to the Health and Environment amendment. Any discussion on kicking it out 1 year? Seeing none, I'll close on my amendment. All in favor, say aye. Those opposed, no. In opinion of the chair, the ayes have it. The ayes do have it. The bill is amended. Back on the original bill, the chair has no other amendments. Go ahead, Representative.
Thank you, Mr. Chair. I move that we pass out House Substitute to Senate Bill 158 as amended favorably for passage.
Thank you. Do I have a second? Somebody said second. Representative Carpenter seconds it. All in favor say aye. Those opposed, no. Opinion of the chair, the ayes have it. Division has been, who called division? I just want to put that on my record. Division has been called for. All in favor, raise their right hand. All opposed? Okay, keep them up, please. Thank you. It's 12 to 8? 12 to 8. Anyone wish their vote recorded? Okay, just take, you're going to have to keep them up. They got their thumbs up or thumbs down. Potter is a yes. Clayton is a yes. Who? Wooders is a yes. Heiberg is a yes. Okay. And for no's?
You have
Jacobs? Wagner? 10?
Yep.
Okay. But the vote was 12 to 8. It passes out. Folks, you will probably see this again at some point in time. Maybe see it several times. Again, I said my speech at the last meeting. I didn't think we would meet again. But you should never say that in the legislature. It's like you should never say a bill's dead, because it can always come back. With that, I want to thank you for your hard work today. We will be on the floor at 10 o'clock. We are adjourned.